Emily Collins, and I co-teach the Environmental Law Practice course, which is a second, upper level course. Second and third years take it, although it seems like mostly second years take it because it's the foundational environmental law course or the environmental law curriculum. And I also, we have the unique experience of not just being co-teachers, but also I'm a clinician, and Anne's a legal writing faculty member, and we collaborated on this after having spent a little too much time perhaps on our curriculum committee at the University of Pittsburgh. But we developed this course really kind of on the heels of our experience on the curriculum committee, but also because we were having a lot of discussions about what really is practice ready based on my clinical experience and based on Anne's experience with students in the first year legal writing program. And how do we get them from their experience in that first year to the clinics?
Which, by the way, was fairly different experience. I mean, we had very different notions about practice ready and how ready our students were after the first year going into the clinics. The clinics told a completely different story.
Yeah, and I think if you talk to most clinical faculty members, they'll tell you that they don't teach writing in the clinics, or at least very few clinicians teach writing in the clinics, and it's it's difficult for us to take the time to really factor that into our seminar component. So in my clinic, I teach interviewing and counseling in my first semester seminar, and then depositions and administrative hearing skills in the second semester. So, thinking about how to incorporate a writing component into that became very difficult. So the best place to put, kind of the transition curricula is certainly in the upper level, but before students are getting into clinics. So most of the students that we have are taking environmental law and practice in their first semester of their second year. So I'll tell you a little bit more about our goal is really transfer, and I know that's a buzzword. A lot of people talk about transfer and think about how exactly we should be placing skills and sequencing assignments so that we are thinking about transfer in the right way. The process that we used was one that came from the university kind of as a whole. The University of Pittsburgh has a really nice Center for Instructional Design and Development, I think it's called. And they helped us quite a bit come up with the process that we needed to use to really think about how to design this course. So we developed the course by using a learner-centered model, at least, that's the kind of the flow chart of sorts that we used. And it focused both on student and client needs in a practice setting. And to the extent that you want to distinguish, it was a clinical practice setting more than it was, a practice setting where you'd be billing, to the extent that that matters. So we were considering course objectives, assessment methods, and the kinds of documents that students were routinely producing in clinical practice. And we did that in a way that wasn't really linear. And that's hence the arrows there. So it's not that we came up with objectives and had those set in stone and moved on to the next thing. We started with objectives. But as we thought about how to assess learning and the activities that we would focus on, we refined objectives quite a bit, and in turn refined our assessment methods and activities. So it's kind of a work in progress all the time is the point of the slide for the most part. And we continue to do that. It's not something that and I think this conference is a testament to that we're all kind of working on this. But I don't, when you're hearing some of what we've done, I hope that you keep in mind that refinement of objectives is something that can always be done. So when when you're thinking about practice-ready assignments, really think about continue to think about what your objectives are, and if you refine your objectives, how those assignments would be changed. So.
Okay, so part of what we looked at when we started to define those objectives was also our motivations for teaching the course and why it made sense to collaborate on this at all. It indeed does. I think it does. This is the second year that we've just finished. And so one of the things that we talked about was that writing is more than a communication tool. It is actually an analytical tool, so that students should have a really solid understanding that they're using writing not just to produce this final document, but it's actually helping them to integrate this new area of law. So it's fundamental in terms of incorporating environmental law in the Clean Water Act, but also then to problem solve, brainstorm, and then also communicate. So we also wanted them to have a real understanding of themselves as problem solvers, which we were finding they were not having that sense of themselves, particularly between the first and second year, and then maybe going out into practice yet again. They didn't really know their ability to analyze a problem, come up with a solution, and actually take authority for that solution. They were falling down in that area. And they couldn't articulate it in job interviews very well either. So that was part of what motivated us. And then we wanted them to remember that learning is collaborative. And so the fact that we co-teach has actually been a good source of modeling that collaboration. So there are points we're in the classroom together, and I know nothing about environmental law. Maybe now I know more. But I can sometimes ask the question for the students who are having a problem figuring out how to ask the question that they have. And it's actually usually a genuine question that I do have, but I'm not so afraid to ask it. I can model that. And Emily's able to do the same sort of thing. Well, let's talk about how you would adapt it to this client situation in the case of a client letter. So that's worked effectively. And then we also believe that just this co-teaching bridges the gap between the first years and the upper levels. Clinicians and legal writing people actually have a lot in common, a lot of common goals, but they don't often collaborate together for some reason, and we tried to explore that a little bit, what was going on. And one of the things we thought that, I don't know what your reaction to this would be, but that legal writing tends to be very document-driven. We're concerned about the documents. The clinicians are very client-driven, and it leads to a different type of course. And so we had to sort of come to terms with how we would address that. So then the other part of looking at objectives was painstakingly coming up with these outcomes, learner-centered outcomes, and this is what we worked on with the instructional designer, and she would have us refine these skills till we just wanted to scream, oh no, we don't care what they learn. But yeah, so there were several words we would use, understand, and she would say, no, yeah.
That became an idea at our 310 years ago. I know.
Yeah, understand.
No understanding.
So we now have a problem ever saying we want our students to understand something. Yeah. So we looked at these goals and thought about what it was that we wanted our students to achieve. So they're apply, analyze, assess, and then use this written communication in this form. Never understand. Never understand. Yeah, they might feel like they don't understand certain parts of the year. So then we thought about how we could possibly assess these things that we wanted. And actually what we came to articulate there at this point was we were trying to measure their ability to transfer skills. And that was not so easy to figure out how to measure. And part of what we wanted to get them, the place we wanted to get them to was to be able to handle uncertainty. And even though they know after first year that there's no black and white, there's not one right answer, they were having trouble recalling those skills when they actually got into the second and third year, and feeling, again, that they were crafting the solution to these messy problems, and there was a wide range of acceptable answers. So the
some of the things that we use to assess them are actually classroom participation. We expect that they actively participate in classroom discussions and give peer reviews, or talk about how to review assignments. We give them things that we've written, we've seen today. We have 3 graded assignments, which Emily will talk about in a minute in a little more detail. We use a closed memo, a comment on a proposed rulemaking by the EPA, and the final assignment is an opinion letter. And then we have them put all of those things, we give them feedback, we grade those, we give them an opportunity to revise, and put those into a portfolio so that they have a final product that shows sort of their whole experience. And then we ask them to do one more thing. We ask them to do a reflective essay that actually looks very carefully at those writings, and particularly pick 2 of them, and to assess how they feel that those writings represent their strengths and weaknesses as attorneys, and how they plan to capitalize on the strengths and improve on their weaknesses. And then they turn that portfolio into us. And, you know, a little more about the different activities.
Yeah, so the 3 major assignments that we give them are what Anne mentioned. And the only tricky part about this is that there are actually 2 mini assignments that lead up to the last one, the opinion letter. And the reason that we do that is because in the clinic, I often have students writing opinion letters, just kind of churning them out for clients. And we always need them to do some kind of legal analysis before they actually get to the process of writing the opinion letter. So how we tried to simulate that in the classroom was to have 2 mini memos submitted to us, really just 2 pages of just legal analysis that would kind of give them comfort with their opinion, with their ultimate opinion that they needed to give to the client. And they could transfer that formal analysis to something that would be a little more colloquial to whoever their client is. We used a fairly sophisticated client for this year's assignment, so that they got the gist of reporting to the president of a company. So some of them really didn't like that. They wanted to write to the environmental group instead of to the president of the company. But I bet more of them will be doing the writing of opinion letters to the president of the company.
A lot of oil and shale gas in Pittsburgh.
Yes.
So.
The shale gas boom.
Yeah.
I work in it.
That's right. That's right. So we tried to sequence these and build on skills and familiarity with various pieces of the puzzle in each one. And I think that's really the major point that we want you to get out of talking about these assignments, is that we discovered after the first year of teaching that we really did need to maintain stability from the first year in at least the first assignment, and then sequence things to add some of that uncertainty in throughout the semester. And that was the trickiest part. I'm not sure we completely got it in our second year, which we just completed, but it did help a lot. So I'll talk a little bit about how we left things in a stable state, and then how we added in some of the pieces of the puzzle to get them to something I'd expect them to do in the clinic.
We were sort of surprised too with the closed memo. I have their familiar source of law was the statute, but actually it was sort of shocking how they didn't know how to use a statute, really. They were so used to case opinions that they couldn't talk about a statutory analysis. They always wanted to jump right to the case opinions, which is something the clinicians have been saying for years, but everybody was resisting. And we said we always cover statutory interpretation and legal writing, but that wasn't transferred.
Yeah, and I think it's true that the students have been given the analytical skills that they need to analyze a statute. They're just not familiar with it as a source of law. So we only, for the closed memo, they weren't allowed to use cases at all. They were only allowed to use the statute. And that was, kind of the limiting factor for them. And they had a really hard time with it. We spent 2 classes, just stay on the resource memo. We spent at least 2 classes on plain meaning analysis. And even then, there were students who wanted to put in case law before they got to, analyzing the text of the statute. So we thought we were giving them a familiar source of law, and perhaps we've learned from that that's not correct. But they certainly did understand how to put a memo together. They knew what it should look like, so that was kind of stable for them. And they knew how to write to a supervising attorney. So those were things that helped them, but that we found that they needed a little more support in using their analytical skills, the analytical skills that are involved in statutory analysis, even with that, familiar closed memo.
What we learned from the first year was that step was important in getting them to understand how a regulatory agency would address a statute and to make an independent analysis of the statute and not just rely on EPA's analysis of that statute. And that was a hard meeting to make.
And in the closed memo, one last thing, we did introduce a client to them. So we made a point of making sure that they knew who this person was and what their interests were. And we did it this year with a videotape of me interviewing someone, and I'm not sure if we'll repeat that or not, but students were thrown by it, to say the least. In any case, I like the idea of introducing a client throughout, and we stuck with that client in the next 2 segments. Okay. Yes, you're there, I'm sorry. All right, so the proposed rulemaking, this is a completely new genre for them. They just, our idea was, let's add in rules and rulemaking in the second assignment, since it's so extremely important in the field of environmental law. We're sticking with the Clean Water Act. It's really not that different than what we've been analyzing in the statute so far. But the agency here gets, we have an agency actor and decision maker, so it's a different audience who they're writing to. And the idea, we're trying to build on the idea of statutory analysis here, because they're still needing to make sure that they understand statutory authority to see if the agency can indeed do what they're proposing to do. And we try to highlight kind of the malleability of law, that you can interpret, the agency has the ability to interpret the statute in a way that would make law in a certain way. So we placed them in the role of an advocate for the second assignment. They weren't just telling the supervising attorney what it is that they came up with for their analysis. And we used the same client in the proposed rulemaking. They had a hard time with it.
They had a hard time seeing this as advocacy.
Yes.
That they actually have a chance to shape the regulation and the rulemaking, and then again, it should be the same as the appellate advocacy skill that they've just went into, but it was hard, and there was less guidance. And of course, we could use clients in the legal writing class too. We have fictitious clients, but the trick here was that they were learning the substance at the same time. It was a very difficult area of law and client too. So it was a lot of balls in the air.
Right. For the opinion letter, same client, but again, a new audience. So they're actually writing to their client here. And I told you before that we had them do 2 analytical pieces leading up to this, so that we could kind of give them feedback on that analysis, so they know what they should be saying to the client, or the kind of the range of things that they could say to the client. And once they completed that formal analysis, it kind of makes sense to them that once they have a conclusion, they can actually communicate it to a client in a different form. So just the physical act of creating those memos, I think, was helpful to them. It gave them some certainty too, even though it seemed so uncertain for them to be telling someone what it is that they think, and realizing that this person's going to do something based on what their analysis is. and that's a big deal. They don't, we found that students, especially in their second year, didn't seem to feel like they had the power to tell someone what they should or shouldn't do, or, you know, that maybe I don't know what you should do. And because of the amount of risk involved and uncertainty involved, you might want to hold off on doing that thing, right? So communicating areas of uncertainty became part of this assignment, and telling the client what the range of things that they could do became part of this assignment. And while they were uncomfortable with it to some degree, I think the students ultimately felt like, wow, this is what lawyering is about. So we started with this memo that was going to a supervising attorney, and ended with, you know, how am I going to take that role, essentially of the supervising attorney, right? And take that analysis to my client so that they can do something with it. So it's a moment of, you know, perhaps understanding. Understanding. But I think it turned out pretty well in the end.
Yeah, so just to conclude, we wanted to maybe ask your input on how you would define practice ready and sequencing of assignments in your own materials. And I think for me, this experience has been great because I'm very used to looking at the document and trying to figure out the skills my students need to sort of get to the production of that document. But this has been a unique experience because instead of starting from the document, I've actually had to sort of identify larger skills and how they're going to learn a subject matter through the production of these documents. And that's you know, taken me to a